Rebuild your finances. How a bankruptcy lawyer can help you. Part 1. Overview of the bankruptcy process. Do you feel trapped by debt and unable to escape it? It's not just you. Every year, millions of Americans battle crippling debt, but there is a way out: seeing a bankruptcy attorney. A bankruptcy attorney can assist in demystifying the procedure and providing you with assurance regarding your financial future. Never allow your financial difficulties define who you are. A bankruptcy attorney can provide you the knowledge and advocacy you need to decide what's best for you and your family. Are you thinking about filing for bankruptcy but are unsure where to begin? Did you know? 3 little-known facts. 1. A person or a corporate organization may file for bankruptcy. 2. Not only may bankruptcy be used to discharge debt, but it can also grant an automatic stay that prevents creditors' activities such as wage garnishments, repossessions, and foreclosures. 3. A bankruptcy attorney can assist you in understanding the many bankruptcy options, including Chapter 7, Chapter 11, and Chapter 13, and in selecting the best one for your circumstance. Welcome to Part 1 of our 4-part series on bankruptcy law. The process of declaring bankruptcy may be challenging and intimidating, so it's crucial to have an expert by your side to help you navigate it. A bankruptcy attorney can help you navigate the legal system and make wise decisions throughout the process by offering crucial counsel and representation. Additionally, they may assist safeguard your property and legal rights, improve your chances of winning, and guarantee that your case is handled properly and swiftly. Employing a bankruptcy attorney might give you financial relief and peace of mind. People and corporations may reconstruct their lives and obtain a fresh start financially with the aid of a bankruptcy attorney. A trustworthy attorney who can represent you, offer guidance, and support you at every stage of the bankruptcy process is essential to your case's success. A bankruptcy attorney can offer the expertise required to maximize the bankruptcy process and assist in helping you recover your finances. In this video, we provide an overview of the bankruptcy procedure and the forms of bankruptcy that are accessible. Let's start by outlining the 3 different kinds of bankruptcy. 3 different bankruptcies. The 3 most popular forms of bankruptcy that people and corporations file for each have different qualifying criteria and filing processes. 1. Chapter 7 bankruptcy. This is for people or corporations with little to no ability to repay their debts. Liquidation bankruptcy may be an option. Most unsecured obligations, such as credit card debt and medical expenses, are dischargeable in this sort of bankruptcy. But some possessions, like a principal property or a car, could be safeguarded. 2. Chapter 13, or reorganization bankruptcy. This is intended for those with steady income who are unable to pay off their debts through a payment plan. This kind of bankruptcy enables people to maintain their assets while repaying their debts over a 3 to 5 year period. 3. Chapter 11 bankruptcy. This is a different type that's typically utilized by corporations but is also an option for people who have a lot of debt. This kind of bankruptcy enables restructuring of a firm or person's debt and assets, enabling them to keep functioning while gradually repaying their creditors. These are only broad overviews of the various bankruptcy kinds. An expert bankruptcy lawyer may offer further details on which type of bankruptcy is most appropriate for your circumstance. Comment on what you think about this. And be sure to click on our like and subscribe buttons. Let's now talk about the 7 processes required to file for bankruptcy. 7 steps to declaring bankruptcy. It is advised to have a lawyer assist you because declaring bankruptcy is a difficult procedure with many phases. However, in general, the 7 steps required in declaring bankruptcy are as follows. 1. Establishing eligibility. Finding out if you qualify for bankruptcy and, if so, which form of bankruptcy is most appropriate for your circumstances is the first step. An attorney for bankruptcy can help you with this. 2. Credit counseling. You must finish a credit counseling course via an authorized provider before you can file for bankruptcy. This course aims to assist you in assessing your financial condition and comprehending the effects of filing for bankruptcy. 3. Prepare and file petitions. Once your eligibility has been established and the credit counseling course has been completed, you must prepare and file the proper petitions and schedules with the bankruptcy court. Forms including a bankruptcy petition, a schedule of assets and obligations, and a statement of financial affairs often fall under this category. 4. Attend the meeting of creditors. Following the filing of your petitions, you must appear at the creditors' meeting. You will be questioned under oath at this meeting by the trustee assigned to your case and by any creditors in attendance. 5. Complete debtor education course. You must complete the debtor education course after attending the creditors meeting. You are expected to learn about personal budgeting and money management in this course. 6. Receive a discharge. If your bankruptcy case is approved, you will be granted a discharge of your obligations, which exempts you from personal liability for most of the debt stated in the case. 7. Close the case. The case will be ended after the discharge has been granted, and the debtor will no longer be obligated to make payments on the discharged debts. A bankruptcy attorney may provide you further details on the exact stages involved in your case. The process might vary based on the kind of bankruptcy and the country you are in. We're halfway through our video. Do click on our like and subscribe buttons for more good information. Now, let's discuss the potential benefits and drawbacks of bankruptcy. Benefits and drawbacks of bankruptcy. For people and corporations who are drowning in debt, bankruptcy can provide several advantages. 4 possible advantages are as follows. 1. Debt relief. Discharging or reorganizing most unsecured obligations, such as credit card debt, medical bills, and personal loans, is one of bankruptcy's most important advantages. Those who are having a difficult time making their debt payments may find this to be a much-needed relief. 2. Automatic stay. When you file for bankruptcy, an automatic stay is put in place, stopping most collection efforts by creditors, such as foreclosing on your home, taking it back, and garnishing your wages. The tension brought on by persistent creditor harassment may momentarily subside as a result. 3. Asset protection. In some circumstances, bankruptcy can help you preserve some assets, like your home or car, by granting exemptions that prevent assets from being liquidated in Chapter 7 bankruptcy or by enabling you to maintain assets while repaying debts in Chapter 13 bankruptcy. 4. Financial fresh start. Filing for bankruptcy can provide you a financial fresh start by wiping away or rearranging most of your unsecured bills and relieving you of the stress that comes with having too much debt. It's crucial to remember that bankruptcy also includes 4 disadvantages, including 1. Some debts are not dischargeable in bankruptcy, including some bills related to school loans, taxes, and alimony. 2. Cost, as the cost of filing for bankruptcy can be an expensive procedure, and it could be necessary to hire a lawyer, which would raise the price. 3. Public record, as it might be challenging to keep bankruptcy procedures secret because they are a subject of public record. 4. Credit rating. Bankruptcy filings can negatively affect your credit score and remain on your credit record for up to 10 years, which can make getting credit in the future more challenging. Before making a choice, it's crucial to examine the possible advantages and disadvantages of filing for bankruptcy. A bankruptcy lawyer can provide you additional details on how it can affect your circumstances. Comment on what you think about this. Conclusion. An expert attorney can make sure that all required documentation is filled out completely and precisely, and that it is filed on time. On your behalf, they will be able to negotiate the legal system and make sure your rights are upheld. You may get the most from the bankruptcy process with the aid of an expert lawyer. A bankruptcy attorney can assist you in navigating the legal procedure and guarantee that your documentation is correctly and promptly filled out. Additionally, they can represent you in negotiations with creditors and provide you advice on the exemptions that are available to safeguard certain assets. Finding a lawyer with whom you can communicate easily and who also possesses the training and expertise required to handle your case should take some time. It's crucial to get legal advice from a trustworthy bankruptcy attorney if you're thinking about declaring bankruptcy. You can get the direction and assistance you need to work your way through the legal system from a lawyer. Avoid attempting to navigate the complicated bankruptcy procedure by yourself. A lawyer can help you make the most of the debt relief options available to you. We provided an overview of the bankruptcy procedure in this video. In our upcoming video, we'll discuss the job of a bankruptcy attorney, how they may assist you with the process, and how crucial it is to have a lawyer on your side. Comment on what you'd like us to feature next in our channel. Check out our playlists for more useful information like this. And remember to hit the like and subscribe buttons. Thank you for watching and see you in our next video.